Heteronormativity is a concept coined within the literature on gender studies. It refers to the set of cultural, moral, and legal standards that reflect the dominance of a certain way of sexuality over others. Specifically, it asserts the superiority of heterosexuality over homosexuality. Heteronormativity also entails discrimination against other sexual minorities, including bisexuals, transgender people, transsexual people, and intersex people, formerly known as hermaphrodites. This alleged superiority is translated into moral and legal norms that rule the way people should behave. Some prominent examples of these moral and legal standards are the moral norms and laws forbidding sodomy as a criminal offense and the moral and legal rules prohibiting marriage between same-sex couples. As other issues have been deemed more pressing during the last 60 years in the human rights movement, discrimination regarding sexual orientation has been given little attention under international human rights law. Indeed, there is no reference to sexual orientation or to gender identity in the Universal Declaration of Human Rights, nor is it protected under the International Covenant on Civil and Political Rights. At best, these instruments could bestow protection to sexual minorities indirectly. Article 7 of the Universal Declaration grants the right to legal protection against discrimination. The International Covenant on Civil and Political Rights, on its part, protects private life in its Article 17, and it sets forth equality before the law and the right to equal protection of the law against discrimination based on, for instance, sex or social condition. Article 1 of the Universal Declaration of Human Rights also states that every human being is born free in dignity and rights, and declares that the entitlement to human rights must not be hindered by discrimination based on sex or any other condition, among other categories. Also, Article 12 protects the right to privacy. The reference to sex in international instruments was initially interpreted as banning discrimination against women. There is isolated case law in the sense that sex includes also sexual orientation, identity, or preference. Today, however, these categories are usually subsumed under the open-ended expression of other status. Since 1994, several UN special organisms have claimed that the right not to be discriminated for sexual orientation is implicitly covered by specialized human rights treaties, such as those pertaining to refugees, civil and political rights, social, economic and cultural rights, and women's rights. Furthermore, in 1991, Amnesty International started considering as prisoners of conscience those people imprisoned because of their sexual orientation or because of sexual intercourse involving consenting adults. However, despite major efforts by some states, there was no express inclusion of sexual orientation in the final document of the Fourth World Conference on Women, held in Beijing in 1995. Later on, the UN General Assembly approved a resolution in 2002 against arbitrary executions in which discrimination based on sexual orientation was expressly forbidden. Thereafter, in 2011, the UN Human Rights Council issued its first resolution on sexual orientation and gender identity, condemning discrimination on such basis. Also worthy of note are the Yogyakarta Principles on the application of human rights law in relation to sexual orientation and gender identity, drafted in 2006 by international experts. These principles state the existence of legal obligations for states to protect and fulfill human rights for sexual minorities without discrimination. The states opposing to these developments at the international level, mainly Islamist republics but also the Holy See, have stressed out that discrimination should be fought on every basis, be that color, race, gender, or religion, So they claim that there is no need to focus on a particular cause, such as sexual orientation. The Holy See, in particular, thinks the protection of the traditional Christian family trumps the allegation of discrimination in areas of marriage and adoption. There are two rulings worth mentioning regarding sexual identity, both stemming from the oldest regional systems for the protection of human rights, Europe and the Americas. In 1981, in the case Dudgeon versus the United Kingdom, the European Court of Human Rights declared that laws punishing sodomy violated the right to privacy under the European Convention of Human Rights. While this can be considered to have happened too late, in other parts of the world, such as today's Uganda or the Caribbean, it would be deemed early enough, due to existing national laws criminalizing sodomy in those places, in breach of international obligations. In 1994, the UN Human Rights Committee, the supervisory body for the International Covenant on Civil and Political Rights, concluded in the Tunen case that Tasmania's sodomy laws in Australia violated the rights to privacy and to equality. In 1997, the European Union signed the Amsterdam Treaty, which for the first time expressly prohibited discrimination based on sexual orientation in an international treaty. In the Americas, in 2008, the Organization of American States issued a resolution reaffirming the right to equality and non-discrimination based on sexual orientation and gender identity. Afterwards, in 2012, the Inter-American Court of Human Rights decided in the case Atala against Chile that family laws prohibiting a lesbian mother to keep custody of her children were contrary to the rights to equality, non-discrimination, and privacy. Both the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights state that marriage is to be celebrated only between a man and a woman. However, the erosion of the heteronormative paradigm has led to the claim for equality of access to marriage for every couple, whether homosexual or heterosexual. Those in favor of equality of marriage hold that, in a democratic society, such an important social institution must be open for every citizen and member of the community, no matter their sexual orientation or gender identity. Conversely, those against homosexual marriage take quite different approaches. On the one hand, conservatives argue that heterosexual marriage is a cultural and religious institution that admits no reform without risking degeneration. On the other hand, radical sexual liberationists, such as the queer movement, claim that marriage itself is just another heteronormative cage that society has imposed over people to oppress them. Now, this discussion has led to legal solutions in several legislations. The solution of a civil union amounting to, but not the same as, marriage was first approved by Denmark in 1989. And then adopted by other countries such as Argentina in 2010. The alternative solution of extending marriage to homosexual couples has been chosen by the Netherlands, Belgium, the state of Massachusetts in the United States, Spain, Canada, South Africa, Norway and Sweden, the Federal District in Mexico, Portugal, Iceland, Argentina, Denmark, Brazil, France, Uruguay, New Zealand, the United Kingdom, and Luxembourg. Please visit mookchile.com and see you in the next class.